Justice and the honorable judges of this court, I want to start first by thanking you very much for admitting me as amicus in these proceedings. I believe myself that this is a good tradition that should be followed into the future, that the Attorney of the Republic should have an opportunity to address the court on matters of great public interest, and I do thank you very much. Secondly, I want to reassure the court that I am consciously aware that no matter what I may say myself or my distinguished assistant, Mr. Mutinda, appearing with me, or Mr. Kaumba, the judgment of this court will be delivered by the judges of this court in accordance with the Constitution and the law. What I think I can do, my lords, and I will be asking you with your very kind permission, should I get very close to my 20 minutes, I will be asking you as a friend of the court itself for a little bit more time, but I think it may not be necessary. We wish, my lords, to share with you the benefit of our reflection on a number of issues that we have already framed, and I adapt in full the submissions we have filed, which is the amicus brief, and the 3 volumes of authorities that we have placed before you. My lords, the law requires the Attorney General of the Republic of Kenya to protect and uphold the rule of law. So I am here with my colleagues not to take sides with any of the protagonists who have engaged me for the last 1 year in a lot of litigation in the High Court, in the Court of Appeal, and I am now happy to see that this is the end of this journey and the matter will be in your safe hands. My lord, I would like to start by making one point. To the question, in answer to the question that I have framed, that is the question, what is the constitutional and legal standard for the presidential election as envisaged in our Constitution? I want to start by saying, my lords, that there is a jurisprudence that has been urged here by the various parties that I myself do not accept to represent the jurisprudence of Kenya on the question of how you determine constitutional questions. And it is this: it has been suggested to my lords that when a question about the election of the president, for example, or probably all elections in general, is raised, then the court should go to the Constitution and the Constitution will yield an answer that is clear and that is determinative of the question. I want to suggest that that is not a proper approach. And I want to submit as follows. The Constitution is not an election statute. The Constitution is not an election statute. It contains the principles that should be observed in creating the electoral system. And to the extent that it is suggested by many of my learned friends here from both and sometimes multiple sides of these presentations, that the Constitution can yield an answer to whether the election was properly conducted, that is not true. What then is the truth? The truth is that the Constitution itself envisages that after it has set out all these broad principles, Parliament shall make a law That is the language of Section 82. Section 82 of the Constitution itself recognizes that Parliament shall make a law. So to where will a prudent lawyer go when he is confronted with a controversy as to whether an election has been properly or improperly conducted? A prudent lawyer will go both to the principles in Article 81 and 86. Then he will ask himself, what is the law that Parliament has made under Section 83? And that will be a whole range, and many of my colleagues have presented this to you. There will be the Election Act 2011, the Election Regulations 2012, the Election Technology Regulations 2017, the Parliamentary and County Election Petitions Regulations 2017, the Campaign Financing. It is a whole regime of law. So let me make my submission on this point. The correct jurisprudence is that the Constitution and the law must be read harmoniously, together. So in my very humble submission, a good lawyer will go to Article 81, go to Article 86, look at Article 83, then go to the entire regime of law. And let me add this, my lords, because I think this is another aspect of the new jurisprudence that I personally don't agree with. The Constitution is not a statute about affidavits. We have a statute about how affidavits are to be drawn. The Constitution is not a statute about evidence. We have a statute about evidence. The Constitution is not a statute regarding the procedure of the Supreme Court. We have a Supreme Court Act and Supreme Court rules. That's where a prudent lawyer will go to look for the procedure. I therefore would like to make the submission that this court must continue to resist an invitation to avoid clear black letter law, number one, to ignore clear black letter law, number one, and two, clear binding precedent. Because, my lords, if fidelity to law means anything, it means respect for the law. And no court, no jurist, should purport to interpret a law by ignoring it. They used to say, my lords, in the old days, but patriotism was the last refuge of a scoundrel. These days, the spirit of the Constitution is the last refuge for a poor jurist. Where the Constitution speaks in clear and equivocal language, the court must find that that is what the drafters of the Constitution meant. Many people in this room are rightly very, very proud of the role they played in having this Constitution get to where we are now. And there are many on this side and as many on that side. But precisely, my lords, because we are so heavily invested in this Constitution, we must respect it. And the way to respect it is to remain faithful to its very clear terms where that is possible, and only to search for its spirit where there is ambiguity, where there is lack of clarity, but not to start with the spirit so that the spirit overrides the black letter of the Constitution. My lords, I can say this with tremendous respect. Whenever the court is invited to the spirit of the Constitution, it's being invited to decree a political preference of the party that is making the case. And I urge you not to agree to that. So what is the true test of how the election should be conducted according to the Attorney of the Republic and his two able assistants? It's a simple one. It's in paragraph 9 of our submissions. The court will ask itself a simple question. Was the election administered free and fair? Now, to determine whether it was free and fair, the Constitution would then look at the circumstances, which is impartiality, neutrality, efficiency, accuracy, and accountability. How will the court determine that? By reading the Constitution alongside the election law, not as two distinct bodies of law, but as one. It is one body of law. The Constitution, as the Bible says, begat the Election Act, and the Elections Act begat the election rules. They are not different. They are the same. I will concede the point made. If there is a conflict, a clear conflict between the Constitution and the electoral law, of course, the Constitution would trump the Election Act. But that has to be demonstrated. It's not to be inferred. It is not to be assumed. I want to make another point as time is moving, which has been made by other people, and I'll be very brief about it. It's at paragraph 11 of my submissions, and it goes on until paragraph 19. It is my second limb of submission. Elections are not about politicians. Elections are not about politicians. Elections are not about political parties. Elections are about voters. And to the extent that we develop a jurisprudence that forgets that we held the election in the first place to recognize the sovereignty of the voter to be governed by a government of his choice, then we will make an error. So we need to keep going back, even as we ask ourselves, and I'm coming to that as my second last point, when can you upset an election? We must keep the voter in mind. It is his election. It is his will. It is his sovereignty. And I have made that argument at great length there. I will not repeat it. And I want to add in that respect that I have placed before your lordships material showing that the Republic of Kenya, other than in the Constitution and its laws, is party to international conventions and treaties which reinforce her own commitment, the Republic's own commitment to an open, transparent, verifiable election. And I think you could, my lords, when you have a moment, have a great look at that. And I am persuaded by the South African Supreme Court decision in Richer versus Minister for Home Affairs on the vote to right, sorry, I'm becoming dyslexic, on the right to vote, and why it's so important for the democracy that we have established here. Now, let me make another point, my third point, and I think it's been made by other people, but I want to share this with you in very brief terms. the election infrastructure in Kenya changed between 2013 and 2017. And it changed to create greater transparency. And I'm happy to see my learned friend James Orengo here, because we spent so much time with him chairing, and I have placed that material before you, chairing with Honorable Kiraitu Murongi, Senator, the Committee of Senate that debated and collected views from the whole Republic on how to make the amendments that are now set out in great detail in my paragraph 20 to 30. And I will not take your time. But what I'm trying to say, my lords, is we have been moving forward in improving the transparency of elections by integrating technology. But it is false to claim that in Kenya we have an electronic voting system. It is manifestly false. And it is unproductive. It is unproductive and unhelpful, because we confuse the public. We create this false dichotomy and confuse the public that there is an electronic system that is foolproof, and any manual intervention is a suspect. The truth is this, my lords. We have a manual system that has electronic interventions. I made that submission before the Honorable James Orengo. I don't know where he is here. Sometimes the playing field is not very fair, because you go to Parliament and you make a submission to the same person, you will meet in court arguing the same case and so on. But that's a story for probably another day. My lords told me not to address the issues raised by the minor KI case. May I seek half a quarter minute to make a very small point? And it was this. The entire jurisprudence of how to conduct an election was changed by the minor KI case. And this was, I think, 2 weeks before the election. And we cannot run away from that. It is so true. And whether it was changed in favor of the petitioners or in favor of the respondents, my duty is to inform you that it was changed in a very radical way. First of all, the chairman of the Electoral Commission was rendered merely, as far as the presidential election was concerned, he was advised that he had no role after the election had been declared at the voting station. So I wanted you, my lords, to just bear that in mind. I will say nothing more. I will obey your injunction on that. Let me come to my last point, my lord, and I beg you to add me 5 minutes. Okay, my lords, my two last points are this. When you are told that the election cannot, that in Kenya we have reached a point where a winner cannot be otherwise, his win cannot be impeached, it is not true. It is for failure to appreciate the several petitions you can have. You can have a petition saying the winner wasn't qualified in the first place. An election didn't happen in parts of the country. People who didn't vote, who shouldn't have voted, should voted. Let me then, because you have exercised your discretion, come to the last point, and it is this. My lords, I beseech you to do one thing. Not about this case, because this case has many learned people arguing about it, about the future of our jurisprudence. Stabilize the law. Create continuity and certainty. You are being asked, my lords, today to do what Martin Luther, the great philosopher, scholar, was asked to do. When he appeared before the Diet of Worms to be tried for heresy, he was asked, why are you the author of these books? And he said, yes. He was asked, do you denounce them? And his answer was, how can I denounce them when they have been perused by pious people all over the world and they have proclaimed their greater spiritual strength as a result? You are being asked to abandon standards that you have confirmed, not in one case, in 7 different cases. How could you possibly do that without throwing the jurisprudence in a tailspin? I urge you, my lords, many jurisdictions looked up to you for guidance. Keep guiding them. Thank you.
Thank you, Honorable.